Thank you so much, JP. Uh, Good evening, everyone. I extend a cordial welcome to all of you on behalf of the Campus Law Center, Faculty of Law, University of Delhi. Today, we have among us Mr. Gautam Bhatia, a lawyer and a constitutional law scholar, and an author of two well-known books, Offend, Shock or Disturb, and The Transformative Constitution. Today, he has agreed to share his thoughts with us on right to privacy pre and post Puttaswamy. Having been a part of the legal team challenging the constitutionality of the Aadhaar project, his insights on whether the Puttaswamy judgment has succeeded in providing a firm ground to right to privacy in India will definitely help us today to understand how this specific right has unfolded in our constitutional history. With this, I would now like to invite Mr. Gautam Bhatia to address this virtual gathering.
Thanks. Am I audible? It's all
yes,
working?
Yes, you're audible. Yes.
Okay. Thank you for inviting me, and I hope everyone's doing well in lockdown, or as well as it's possible to be doing given the situation. Hopefully, we'll all be back, in normal circumstances soon. So I thought that given the topic, the journey of privacy pre and post Puttaswamy, what I would do is I would basically give you like a historical overview of the evolution of the idea of privacy, how it began, how it came to India, the various controversies over its existence, its scope, what the Puttaswamy judgment does, and what are the ideas and the options and the possibilities going forward in a post-Puttaswamy era. And after I've done, we can open it up to questions, answers, and discussion. So that's how I think we'll proceed. So if you look at the history of the idea of privacy, it's a very, very old idea. Way back in the ancient world as well, whether you look at ancient Greece, Rome, or here in ancient India, there was a clear sense of the distinction between public space and private space. In India, you had the idea of what is ghar and what is bahar. That was always a key idea in ancient Indian jurisprudence. In ancient Greece, you had the idea of the polis, which is the city, and the oikos, which is the household. So that distinction between there being some things that are of a public character, and therefore certain sets of rules and ideas apply to public spaces, whereas there are some things of a private character and different considerations applied there, is a very, very old idea that's common to all civilizations. But in its present form, privacy as a right, or the idea of privacy as a claim that you make against the government, evolved towards the end of the 19th century, and it evolved in the US. So in the US, the effect of modern life, the effect of increased powers of the state, and this understanding that the lives of individuals and individual people were open to scrutiny in a way that they hadn't been before, necessitated the idea of privacy as a legal concept. And so in the 1890s, you had a very famous article by Warren and Brandeis, and Brandeis went on to become a Supreme Court judge. And that article is credited with the evolution or the birth of the modern legal concept of privacy. Now, this original idea of privacy as it developed in the US in the end of the 19th century was focused upon the idea of space. By space, I mean that the idea was that, look, if you look at certain spaces like the house, in an individual's house, so the threshold of the house and the door of the house is where the state can't go beyond. So if you go beyond the house into public spaces, that's where the state's law, the state's writ will run. But when you are at the door of the house, beyond that, the state can't go. And you have this famous saying, "A man's house is his castle," and this other very famous saying from the UK, common law, that you have a peasant, and the peasant's house might be breaking down, it might be crumbling, the rain might come in, but the King of England can't go in with all his army. So there were all these ideas of locating and grounding privacy in these concepts of spaces. There are certain spaces that need to be walled off from the interference by the state or by other forces or whatever, because the idea was that for people to develop themselves, develop their personalities, they need to have certain spheres where they can do so freely and without having to conform to the dictates of the state. So that was the original idea, how it evolved in the US in the 19th century. Now, as you went to the 20th century, other cases began to come up. So the most important set of cases, and you see this in India as well, and we'll discuss that, involved surveillance. So basically the state spying on people with the objective of preventing crimes, of figuring out who was planning crimes and using that to stop them. So you had, in the early days, a lot of phone tapping was going on in all these countries. Now, again, in the US, this phone tapping was challenged in the Supreme Court. And in the beginning, the Supreme Court upheld phone tapping, because remember, at that time, the idea of privacy was still very basic. It was still finding its vocabulary, finding its feet. But in that US Supreme Court judgment called Olmstead versus US, there was a dissenting opinion by Justice Brandeis, and Brandeis was the same person who wrote the original piece that started off the idea of privacy as a legal concept. And Justice Brandeis basically located the idea of privacy in what he understood to be a difference of power between the state and the individual. So what he said was that, look, the state has all this power, and there's a great imbalance of power between the individual and the state. And the role that privacy plays is to rebalance that power equation. So if you have a situation where the state knows everything about you as an individual, it knows where you've gone, what you've shopped for, who you've spoken to, what your medical condition is if you've spoken to a doctor, what your marital relationship is if you've spoken to a divorce counselor, and so on, then the kind of power that the state exercises over you will be so grave and so overwhelming that it will be impossible to have any meaningful freedom left. Because with that kind of power, you can be blackmailed, you can be coerced, anything can happen. And so he developed this further idea of privacy as the use or the need for privacy is not just this individual right against the state, but in society, you need to protect the common good by ensuring that you do not give too much power to the state and to state bodies, even if it is meant to be used for beneficial purposes. So that was the idea that he put forward. Now, you fast forward a few years more, and you come to the Indian Constitution being framed. Now, when the Indian Constitution was being framed, as you all know, there was a lot of discussion about what concepts do we, take from other countries and use them here. Because Ambedkar and others said that, look, in all the other countries, you've had time-tested constitutional law, so we don't, in India, need to reinvent the wheel. So we should see what has worked, we should see our conditions, and we should see what we can take and fit to Indian conditions, because that is how knowledge develops and grows over time. So there was a big debate over whether to have a specific right to privacy in the Indian Constitution or not. And some members of the Constituent Assembly actually suggested constitutional provisions along the lines, for example, of the American Fourth Amendment that prohibits searches and seizures of homes, papers, books, and so on, correspondence. So the idea that correspondence must be private, these were all put forward. There was a big debate over including this clause, and in the beginning the clause was included, but in the end it was dropped. So there was no categorical or specific textual right to privacy in the Indian Constitution, unlike, say, the American Constitution, or now the European Convention of Human Rights, or the South African Constitution. And that has, as you all know and as we'll discuss, has caused a lot of controversy over the years. So there was no specific textual right to privacy, but you had a number of other fundamental rights, such as the right to, for example, free speech, the right to life and personal liberty, the right to freedom of conscience and religion, And if you think about it a little more deeply, you will see that none of these rights are actually effective or meaningful unless they come along with a right to privacy. So, for example, imagine that you have political groups that are opposed to whichever government is in power in the center, and we have seen this over our history. From the emergency times onwards, you often have different ideologies that are there in the at the central government level or the state government's level, and you have political groups or organizations that have a very different idea of what a good political idea looks like. And so sometimes to prevent the persecution or the prosecution or malicious prosecution of these groups, it is important that the membership of these groups remain private. As long as they're not engaging in law breaking or doing anything illegal, they will not want to reveal themselves as being members of those groups. A very famous example again in the US, where you had all this repression of black people, and you've seen in the last 2 or 3 days large scale protests in the US. So back in the 1950s, there was this organization called the NAACP, whose goal was to promote the interests of black people because they were being discriminated against in various ways in the US. So what the government used to do was it used to look at the membership lists of these organizations, and then it would basically harass the members, put them in jail, arrest them randomly, and so on. And so the NAACP went to the Supreme Court, and the Supreme Court basically said that, look, the right to free association, right to assembly, is meaningless unless you also guarantee a certain protection to people from being persecuted because of the associations they have and the opinions they hold. And sometimes the only way you can avoid that is by guaranteeing to them a right to privacy. So you can see that privacy is both a specific right in its own sense, but it also flows from other rights like association, speech, liberty, and so on. And that is something that the Supreme Court in Puttaswamy understood, and we'll discuss that as we go on. So you can see that even though the Indian Constitution did not have a specific textually guaranteed right to privacy, it had a number of other rights from which privacy flows as what they call a interstitial right. So between the spaces of the Constitution, you can discern other kinds of rights that are essential to maintaining that constitutional structure. So that was what happened in the constitutional framing in the late 1940s. Now, in the beginning, the Supreme Court went by the pure text of the Constitution. In the MP Sharma case in the late 1950s, the court simply said that, look, there is no equivalent of the American Fourth Amendment to the Constitution in India, so we cannot read in a right to privacy to the Indian Constitution, and of course that's one way of looking at it, and that's of course a valid argument to make. So that's what the position was in India in the late 1950s. Now let's just again depart from India for a moment, because remember that I began this discussion by pointing out that when the idea of privacy first evolved in the late 19th century, it was linked to space. So the house is the private domain, but nothing. And that's what privacy is attached to. Now, in the mid 1960s, in various countries, there was a gradual evolution of privacy and a delinking of privacy from space. So there was a very famous American case where there was a law in the state of Connecticut that effectively prohibited married couples from using contraceptives, birth control mechanisms, because there was some moral ideas about how this is a sin and you should not be using birth control contraceptive devices. So there was a law prohibiting it. Now that law was challenged in the Supreme Court, and the Supreme Court said that, look, there are certain institutions and certain relationships that are so important to society and are so valuable and are in a sense building blocks of society that the state cannot interfere with them. So the family, for example, or marriage, the institution of marriage, these are very, very important social institutions that require non-interference from the state, because people need to be able to enter these institutional relationships on a free basis. And so you had this shift. Privacy went from being connected to space or to physical space like the house, to being connected to relationships or institutions like marriage, like the family. Interestingly, the Irish Constitution of Ireland, specifically says that the family is the fundamental unit of society. And the Irish Supreme Court has used that constitutional clause to guarantee a right to privacy that is accorded to families. So what the decisions within the family are decisions that the state cannot interfere with. So that's the idea there, that certain institutions or relationships are valuable in themselves. And these are the institutional relationships that become the bearers of the right to privacy. So now you have these two concepts of privacy. One is privacy of space, house, and so on. The other is privacy of institutions, relationships, marriage, family, and so on. And what you'll see is that both these ideas of privacy, in a certain sense, ignore the individual. So it's not the individual person who actually has the right to privacy, but privacy is a right because certain spaces should be sheltered or certain institutions should be sheltered. So you have a kind of erasure of the individual. Now, sometimes that may not matter, it may not make a difference, but in other times it does make a very big difference. So, for example, think about domestic violence, right? Which is a massive issue. It's an issue that's come to the fore specifically after the lockdown and COVID-19. There's been an escalation of domestic violence issues across the country. Now, if you go by the idea of privacy as being about spaces such as, the house being a space where the state can't enter, or if you think about privacy as being about relationships or institutions like, the family or marriage, then you'll see that it becomes impossible to tackle things like domestic violence, because these things take place within the home and within the context of institutions and relationships. So that's why you can see that you need to also have, in addition to the privacy of spaces, the privacy of institutions, you also need to have the privacy of individuals. And often that right that the individual has to privacy might actually be enforced not against the state, but against or within the home and within the family in cases like domestic violence. And therefore, you need to have a further evolution of the idea of privacy. And this evolution happened in the 1970s. So then the courts all over the world began to move beyond privacy of space, beyond privacy of institutions, and began to talk about privacy of individuals. For example, in the US, in the famous abortion case, Roe versus Wade, which you all would know about, the right to have an abortion was grounded in the idea of individual privacy. That is, that when it comes to taking certain decisions that are fundamental or intrinsic to personal well-being, intimate decisions, then that is covered by the right to privacy. So now you have these three different concepts of privacy: spaces, institutions, and people. And these, as we have seen, could sometimes clash, and sometimes they would just operate in different spheres. Now, meanwhile, coming back to India, so in the 1960s, the Supreme Court continued with this whole denial of the right to privacy under the Constitution on the basis that there was no textual guarantee. So in a very famous case called Kharak Singh, which involved the issue of police surveillance upon what they called history cheaters or people with a prior criminal record, the question was that there was no law that authorized this surveillance and that it was unconstitutional because surveillance involved nightly visits to this person's house, a record of all his movements and so on. And that, it was argued, violated Article 19(1)(d), freedom of movement, and was effectively a restraint upon the individual and so on. Now, the majority judgment in that case went along the same route as MP Sharma and said that, look, privacy is not a guaranteed right under the Constitution. And so we are going to just look at if there is an actual restraint on this person's movement or if there's any tangible fetter on this liberty. And it found that the mere activity of surveillance was not enough to cause a constitutional violation, and it upheld the surveillance regulations. But in that case, you had a very famous dissent by Justice Subba Rao, who is one of, I think, the most eloquent and of our judges in our history. If you read his judgments in the 1960s, one of the strongest defenders of civil rights that we had, and he was often dissenting in many judgments because he felt that the court was not protective enough of civil rights. So he wrote a very famous dissenting opinion where he said that, look, you have to, first of all, privacy is a right that flows from these other rights like 19(1)D, 19(1)A, 21, and so on. And then he said that, look, it's not just about whether you're physically stopping someone from moving, but if that person knows that all his movements are being surveilled, are being tracked, it will obviously affect his behavior in very significant ways. So if you know that your entire internet search history is being monitored, or if you know that every time you go out, somebody is keeping a record of where you're going and who you're meeting, obviously it's going to have a big impact on your behavior, and it will force you to change the way you behave, and you'll end up, conforming much more to what you think is acceptable. And so Justice Subba Rao pointed this out as being a specific problem of surveillance as it relates to privacy. And you can see that in a certain sense links back to what Justice Brandeis from the US had said in the 1930s, which is that ultimately we need a right to privacy because the relationship between the individual and the state is deeply marked by an imbalance of power. The state is far more powerful than the individual. And so to protect the individual against an abuse of that power, you need to have a right to privacy that will keep certain information, certain basic facts about the person beyond the purview and scrutiny of the state. And that's the underlying logic why you need to have a right to privacy. But that, of course, was a dissenting opinion, and so it didn't carry much weight. Now, interestingly, in the 1970s, in a case called Gobind versus State of MP, a three-judge bench of the Supreme Court did a complete turnaround. And this three-judge bench effectively adopted Justice Subba Rao's dissent. And for the first time, the Supreme Court said that, look, actually, there is a fundamental right to privacy flowing from the Constitution. And it tested police surveillance regulations on the basis of that, and modified and narrowed them down because in their present form, they were going beyond what was allowed by the Constitution. But the key point was that Kharak Singh was a bench of 6 judges, and this MP Gobind was a bench of 3 judges. So Gobind could not have overruled Kharak Singh, and it didn't even mention that it was doing that. It just went along a different path. Now, after Gobind, it became established that the Constitution had a right to privacy, and you had a number of judgments over the next 40 years that in different spheres affirmed that right. So you had the famous R.Rajagopal case in 1994 that talked about a prisoner's right not to have a biography of him published without his consent, because that would violate his right to privacy. You had a number of cases involving medical details that were decided under the right to privacy framework. You had cases involving bank account details, famous case called Canara Bank, which I think I would recommend. It's a very good judgment that located this kind of information within the domain of privacy. And then you had a very famous case called Selvi versus State, 2010, which is also a very interesting judgment, and I would recommend that, which tested the constitutional validity of 3 interrogation techniques by the police: narco-analysis, brain mapping, and the lie detector test. So the question was whether these tests effectively violate the right to privacy and self-incrimination, Article 20, Clause 3. And in a very interesting judgment, the Supreme Court speaks about the right to physical privacy and also the right to mental privacy. So the idea being that you cannot be forced to answer a question, and you can't use machines to basically extract answers from you, because there is a fundamental space in your mind that has to be free from government control. And if you read the judgment, you'll see the effect of privacy in different domains. So you had all these judgments that were taking the law in different directions and elaborating upon the facets of privacy in different ways. But the foundation of these judgments was still shaky, because you had an 8-judge bench and a 6-judge bench from the 1950s and 60s that clearly held that there was no fundamental right to privacy, and therefore all the judgments which came after that were suspect. Now this came to a head in 2015 when the Aadhaar project was being challenged on many grounds, and one ground was privacy. So in August 2015, the Attorney General pointed out that, look, there is this constitutional challenge on privacy grounds, but actually the largest bench strength of the Supreme Court, 8 and 6 in the past, has denied a right to privacy, and all judgments after that are smaller benches. So as of now, there is no right to privacy because all these judgments for 40 years are based on something they can't do. They can't overrule a larger bench. So then the Supreme Court said, okay, we need to settle this question. And so it sent the question to a larger bench. So first it went from 3 to 5. And then 5 judges referred it to a 9-judge bench. So a 9-judge bench could basically relook at the whole question from scratch, afresh, and finally decide the question of whether there was a right to privacy or not under the Indian Constitution. This 9-judge bench would not be bound by any previous bench because they were all of lesser strength. And so you had this 9-judge bench that sat and heard the case in August 2017. And then this 9-judge bench, in what we now know as the Puttaswamy judgment, unanimously held that there is a fundamental right to privacy that is guaranteed by the Constitution, Articles 19, 21, 25, and so on, and that all the previous judgments from Gobind onwards to Selvi and Rajagopal, all of that, were rightly decided. Now, in the Puttaswamy case, it's a very long judgment and it has 6 different opinions. So it's worth reading and thinking about. And in fact, just a couple of weeks ago, there was a volume of articles that I edited with a colleague of mine in the Oxford Human Rights Hub Journal that analyzes the Puttaswamy case and its impact. And if you're interested, you could take a look at that. It has 6 or 7 articles that deal with various facets of that judgment. So the judgment covers a wide range of issues, and to discuss that in full would be the subject of one full course. It's like very complex. But briefly, what the judgment says is that, well, first there's a fundamental right to privacy. This right has different facets. So, for example, one aspect of it is what we know as informational self-determination or informational privacy. This means that there's certain information about an individual, certain personal data that the person has a privacy claim over. Core information like health and things like that. In many cases, religious status, caste status, and so on. That's one facet. The second facet is that there is a right to personal, decision making. So intimate decisions like marriage, like sexual orientation, like abortion, and so on. These are protected by the right to privacy. And thirdly is a right against surveillance. So the right not to be surveilled and the right to be free of government surveillance. And all of these speak to an affirmation of the individual idea of privacy. That is that privacy is not about spaces, it's not about institutions, but it is about ensuring that the balance of power between the state and the individual is maintained to an extent. Now, of course, like any other right, privacy is not absolute. So in certain circumstances, the state, the government, is obviously entitled to infringe upon that right. So, for example, if the government has a credible intelligence or credible evidence that X person is planning a terrorist attack, right? Obviously, the government has the right and the duty to surveil that person's phone and to spy upon that person to prevent the attack from happening. So the right is not absolute. And so the Supreme Court also laid out the circumstances under which you can restrict the right to privacy. And the Supreme Court basically laid down what we now know as the Proportionality Doctrine. So the Proportionality Doctrine is something that has been part of our jurisprudence since 1952, since the V.G. Row case, which is a very famous case in constitutional law, that laid out very clearly that when the state wants to restrict your right, then it must be proportionate. It can't overdo things. It has to, as a famous German scholar said, you can't use a cannon to shoot at sparrows, right? So there has to be a proportionate relationship between what the government wants to do and the right in question. Now, over the years, over the decades, this idea of proportionality has evolved and become more refined and complex. And now it has basically what we know as 4 steps or 4 limbs. So the first limb or the first step is that there must be a law that is legitimate for legitimate aim, legitimate purpose, right? So you can't restrict or infringe privacy without a legal backing. Parliament has to pass a law that sets out the circumstances under which you can do that. And this law must be for a legitimate purpose. It has to be for a aim, like stopping terrorism or promoting welfare or whatever it is. There must be a legitimate aim that the government has. The second step is that there must be a rational relationship between the infringement of the right and the goal. And this you are familiar with from Article 14 jurisprudence, right? There must be a rational nexus between the classification and the goal from Article 14 cases. Similarly, in proportionality, if you are restricting the right for X or Y reason, you have to show that there is a rational connection between why you're doing that and what the goal is that you want to achieve, right? So again, for example, if you want to spy upon only people above 6 feet or above 6 feet tall, right, and your justification is that this will stop crime, but there is no relationship between the height of people and stopping crime. So obviously, like that fails at that level. So that's the second step. Now the third step, and this is the most important step of the test, is what is called necessity, or the least restrictive prong. Now, what this requires basically is that suppose the government has a certain aim, certain goal, and to achieve that goal, it can do either A, B, or C. All these 3 options are open to the government to achieve the goal it wants to achieve. Now, solution A will infringe rights a lot, to a great extent. Solution B will infringe the rights to a somewhat lesser extent, and solution C will do it to an even lesser extent. And all these 3 are reasonably equally efficacious in achieving that goal. Now, if that is the case, then it is the obligation of the state to select that option that infringes rights the least. So if the government has an option of more than one solutions, then the government has to pick the one that will be most protective of individual rights. And if the petitioner can show that actually there was a less restrictive alternative that the government did not pick, then that measure has to fail at that step. So that's step 3. And the last step is an overall balancing. So you look at the importance of the right at issue. If you look at the importance of the state's goal, and see if there is a balance in the extent to which the state has infringed a right. So if you think of our history, so we had this in the British time, we had this law called the Criminal Tribes Act, and that law basically was based upon the premise that certain tribes, everyone by birth is presumed to be a criminal, and so they can be put into camps and removed and taken away from their parents and so on. And that law was repealed after independence. But if you can see here a good example of what would fail a proportionality test, because there is clearly no balance achieved between the state's goal of preventing crime and basically criminalizing an entire group of people without any evidence that specific individual people are actually committing a crime or not. And so in the Puttaswamy case, you had on the one hand an affirmation of the right to privacy as an individual right, and on the other hand you had this 4-step test of when you can restrict that right. And so that was kind of the basis laid by that judgment, which I think laid the basis for a strong privacy right that could actually be used to hold the state to account and make it justify its decisions when it sought to infringe upon the right to privacy. Now, after the Puttaswamy case, you have had a few judgments where the court has implemented that right, and in the High Courts and Supreme Court as well. So, for example, in the famous Navtej Johar case, where Section 377 of the Indian Penal Code that criminalized same-sex relations was read down, it was on the basis of the Puttaswamy judgment that sexual orientation is something that is intrinsic, fundamental to an individual, and therefore, to restrict that, you need to show compelling justification, which the state did not show in that case. In various high courts, for example, the Bombay High Court, you had an important judgment on the issue of surveillance and whether the state surveillance of mobile phones was allowed, and if it was illegal, then what was to be done with the data that was collected. And the Bombay High Court said that, look, given the right to privacy exists, if you have been doing illegal surveillance, then you can't use that data for any evidence in court, and you must destroy that data. In the famous Aadhaar judgment, the Aadhaar project and the Aadhaar Act was partially upheld and partially struck down. It was upheld on the question of making Aadhaar mandatory for subsidies and welfare benefits and for income tax payment, and struck down for bank accounts and mobile phones. And if you see the reasoning of the court when it came to the latter two, mobile phones and bank accounts, you can see a clear application of the Puttaswamy standard, because having found the right to privacy exists, the court then found that the government's justifications, that is preventing shell companies and fake accounts for banks and preventing terrorism for mobile phones, completely failed the proportionality test. So on the bank accounts question, the court held that, look, there is no possible connection between making people get an Aadhaar and preventing shell accounts. You haven't shown any connection, and so this fails the rationality step of the test. And on the mobile phones issue, the court said, look, you can't make the entire country, most of which is completely innocent and has no connection with terrorism. So you cannot force everyone to link their mobile to Aadhaar on the basis that some people might misuse that to, commit terrorist acts. And so you can see how the Puttaswamy standard was applied in these two examples in the Aadhaar case in a way that actually struck down the state action that was taking place. So I'll briefly close, and then we can have Q&A after that. So this was a kind of snapshot historical view of the evolution and development of the idea of privacy, both globally and in India, over the years, over more than a century. The Puttaswamy case, by virtue of its affirmation of the right to privacy as being an individual right, which is required to redress the imbalance of power between the individual and the state, sets the ground for many years of jurisprudence in the future on this issue. You have many other, I think, examples that might come up later. So, for instance, you have this whole issue of marital rape. So, under the Indian Penal Code, marital rape is not counted as rape, and that has been challenged in the Delhi High Court. There's an ongoing case there. Now, given that the Puttaswamy judgment specifically says and refers to the critique of privacy, which is limited to privacy stopping at the threshold of the house or the family, and actually says that in many cases you may need to enforce the privacy right against the family or against the household. It's interesting to see where this case will go in light of that judgment. And you have many other cases involving state surveillance, various domestic violence laws that may now change. The whole issue of abortion might be reopened after this. So you can see that the judgment, if you read it carefully, gives you a ground that can be used in the future to advance privacy claims in many different spheres, the domestic sphere, the public sphere, and so on, against the state and against other bodies as well. And of course, the question of how it will develop is a question that we don't yet know the answer to. That will depend on how lawyers, the public, and judges finally understand this right and how they apply it. So with that, I'll close and we can, go on to a discussion and to Q&A. So thank you.
Thank you, Mr. Bhatia, for that very informative session on right to privacy. In the Puttaswamy 1 judgment, we specifically see Justice Chandrachud trying to ground right to privacy in this whole concept of dignity. The question that we would like to pose to you is that how far do you think this linking of privacy with dignity was important? And this is something which was not done in the previous judgments that we had discussed per se in such an elaborate manner in the previous judgment. How far it was important to make a claim for something that you argue, individuals creating individual right to privacy rather than confining privacy to spaces and relationships.
Yeah, I think dignity played a very important role in the judgment, in the sense that it basically ensured that privacy was given an individual foundation. And so if you read the judgment, as you know, ideas of liberty, autonomy, and dignity all played a role in kind of grounding the right to privacy in Article 21. Now, of course, the question then is that what is dignity? And what do we mean by dignity? And I think that's where we haven't yet had too much discussion or elaboration in Indian jurisprudence. Because if you look at the history, dignity as a constitutional concept basically comes from Germany. And it comes from German constitutional law because of World War II. And in World War II, when the Nazis were in power, the Holocaust happened, and the manner in which they basically denied to the Jewish people any dignity by putting them in concentration camps and then in gas chambers. So that horrific murder of 6 million Jews and various other people, in a way that deprived them of the most basic human dignity. That was what led to dignity being like a core constitutional value in German jurisprudence after World War II. And then from there, it kind of exported to all over the world, and it's now become important everywhere. So I think that going forward, we need to ask ourselves in the Indian context and in our history, our history of discrimination on caste and gender grounds in our past, what do we understand by dignity, and what does dignity mean in specific situations? And once we do that, once we have the discussion, then we can maybe try and ground privacy in this idea of dignity in a more concrete way. But I think that we still have to have that conversation about what we understand by the idea of dignity in the Indian context.
Thank you so much. We have a question from Vineet George. Now, and this question is with regard to Section 9 and 22 of the Hindu Marriage Act specific, and the Special Marriage Act. Because we had seen that in P. Sarita, the court tried to link the restitution of conjugal right as a violation of right to privacy. So the question is, post the Puttaswamy judgment, can it be argued that sections 9 and 22 of HMA and SMA can be considered to be violative of right to privacy?
Give me a minute. Let's have some water. Just give me 2 seconds.
Sure.
Yeah, that's a very good question. And now, in the Sarita case, 1983, the Andhra Pradesh High Court said that the Section 9 of the Hindu Marriage Act, which is restitution of conjugal rights, which allows the court to pass a decree that if any one spouse has unreasonably withdrawn themselves from the company of the other, then the court can pass a decree requiring them to go back, although you can't really enforce it anymore. And that provision actually, interestingly, has no basis in Hindu law. It was actually a completely British invention that was brought from the British Matrimonial Causes Act of 1865, and it was literally transplanted from English law into Indian law. There was no equivalent concept in Hindu law of that kind. Now, the Andhra Pradesh High Court said that that basically by forcing an individual to return to the company of a spouse they have left, that violates the right to privacy, autonomy, to take decisions about your marriage and so on. Now, the Supreme Court overruled that 1 year later by saying that the purpose of this provision was to try and maintain the marital relationship intact, and that's the role it was playing. Now, in the Puttaswamy judgment, Justice Chalameshwar's concurring opinion, in one footnote, he talks about the Sarita case and says that this now might be reopened. And I think if you look at Puttaswamy very closely, I think you'll find some arguments there to reopen this case, because Puttaswamy makes clear that if you have a clash between the right to privacy of an individual, specifically individuals who are in positions of vulnerability or marginalization, against, say, an institution like the family or like marriage or so on, then the right to privacy will prevail in that case. And so I think that it might be worth thinking about whether or what impact that has on Section 9 of the HMA, and it would seem to me that a provision that actually legally compels someone to go back to a spouse they have left would suffer from certain constitutional problems in light of this case. Although interestingly, from what I understand, when I was in practice, I had my chamber had a fair few domestic violence cases, and actually even after I temporarily left practice, my understanding is that in practice the provision is used to actually facilitate divorce, because if you get a decree of restitution for conjugal rights, and in one and there is non-compliance of that decree by the other spouse, then actually then that becomes a ground to seek a divorce. And so in that sense, if this provision right now is not actually exercising any coercive force and actually is facilitating individuals to amicably or non-amicably part ways, then it might actually not have to be struck down. But I think that's another question that is something to be looked at in a constitutional challenge to the provision.
Thank you. So there is a question by Dr. Anju Ali Tiku. And the question is, and this is an argument that is generally made, that emergency situations like present often justify creation of a surveillance state. So in that context, the question sort of asks that how far does apps like Arogya Setu app conform with the idea of privacy and can be justified?
Yeah, I mean, that's a great question. And so I think with Arogya Setu, what I would say is that there are many issues around the app. And to detail all the issues would take a very long time. The petition that was filed by the Internet Freedom Foundation on their website, you can see the petition, and that lists out a number of arguments, and it has the most detailed set of arguments against the app. So if you read that, you'll see what the case is. Just like a basic example, now Arogya Setu, like any other contact tracing GPS-based app, basically says that if you are in proximity with a person who's infected, then you will get a notification that you are at risk, and then you can take appropriate action. The government can take appropriate action. But imagine that there is a wall between you and person X. Now, COVID-19 cannot cross that wall, right? Because like it travels through the air. So if there is a wall between you and that person, you're not at risk of being infected, but a GPS-based app will nonetheless flag you at risk because it's looking at GPS, right? And so what you have is the risk of these false negatives and false positives, where people who are not at risk are flagged at risk, and those who are at risk are flagged not at risk. And so if you want to have like a situation where you're identifying accurately people at risk and taking steps, then that fails if you have these kinds of problems. Now, so you have these kinds of debates worldwide about the utility of contact tracing apps and so on. Now, I think that, but to answer the question in its more abstract way, so I think that this is the thing, right? So the test of proportionality, which is the test that's used to adjudicate upon rights violations, has an inbuilt mechanism that allows for emergency situations to be taken into account, right? So now, for example, in this whole COVID-19 situation, right, you have various steps being taken by the government to deal with that public health crisis. Now, if you were to have a constitutional challenge to, say, some steps on privacy grounds, the test would still ask the same question. The question would be that, look, what is the legitimate aim the government has? The aim is to combat the public health crisis, right? So nobody will dispute that. Okay, so that's step one. Step two, what are the steps the government taking? Do they have any rational connection with the goal, right? that's a very low threshold to fulfill. It should be very easy, because unless something is completely arbitrary, right, there is no reason why the government can't show that there is a rational connection between the step it's taking and the goal of combating COVID-19. The third step, right, is again, so the only question that the third step is asking, right, is that, look, you have COVID-19, right, and say you've taken a step A to combat COVID-19 that violates privacy rights. Now, did you as the government consider looking at B and C as well, which don't violate privacy rights, but also are efficacious in fighting COVID-19? Did you consider that? And if you did and didn't select them, why didn't you do that? And if you haven't considered them, then please consider them. Right? So again, this is not something that will stop the government from efficaciously fighting COVID-19. It just holds the government to account and to ensure that it's fighting COVID-19 in a way that protects rights to the extent possible to protect, given its goals. And the fourth step, which is a balance between the rights and the state goal, again takes into account the fact that the importance of fighting COVID-19 is so urgent and overriding that unless there is some completely disproportionate violation of rights, like putting everyone in jail or something, the balance obviously will tip towards allowing what the government is doing. So I think what you can see is that there is, I think, a common misconception that the right to privacy or the tests that are judicial review operate as tests that stop the government from doing what it wants to do. That isn't what's happening. These tests, what they're designed to ensure is that what the government does conforms to certain standards, and as long as that happens, it's fine. We all understand that the right to privacy and all constitutional rights are inherently limited in view of public concerns. But I think the problem arises when people say that look, COVID-19 is a public health emergency, and therefore there is no scope for any kind of judicial review. Now that's a risk, because for something like COVID-19, the government actually undertakes to itself vast amount of power, right? The whole national level lockdown is an exercise of a large amount of governmental power. And when the government is assuming extraordinary powers, the possibility of mistakes, of abuse is quite high. As Justice Khanna said in his dissenting opinion in ADM Jabalpur, he said, look, our concern is not with tyrants and authoritarians. Our concern is with people of good hearts, well-intentioned, but who become overzealous, in enforcing what they think is the right thing. And so that's why when the government takes more power, the importance of judicial review, of scrutiny, becomes even more pressing, just to ensure that the power is being exercised along the right channels. So that's what I would say. I think that the answer is somewhere in the middle between these two extremes.
Right. And continuing with the same context, how far then do you think that consent plays an important role in this question of data privacy? And what kind of consent also becomes important, whether it's a one-time consent or a continuous consent. So
yeah,
how do we determine the contours of consent also, if it is important?
Yeah, so consent, I mean, so see, consent is of course very important, because if your data is being taken without your consent, then that's a prima facie violation that then the government must justify. So in that sense, consent as a legal principle becomes very important. Now, so this is also a great question, because now across the world, there has been an understanding that data is very important. Data is important both for the individual and for public authorities to be able to craft policies that can reflect realities and target people who need those policies, right? So if you're target for welfare measures and all that, you need to have the data of who needs welfare and things like that. So you need to have a balance between these two things. Now, one way that countries across the world are developing that balance, and the judgment in Puttaswamy also clarifies that, is there something called purpose limitation. Now, what purpose limitation means is this. It means that if you're taking my data, we can for the moment bracket the issue of consent, for a purpose X, right, for the purpose A, which could be for security reasons, welfare, or whatever, then you can only use that data for that purpose. You can't say, I now have your data, I am the state, I have your data, and I will now do whatever I want with it since I have taken it one time, as you said, like a one-time consent issue, right? And that's important because data that you might take from me might be valid for a certain purpose X, but might not be for a certain purpose Y. So every time you're taking my data to use it for a certain purpose, that must conform to constitutional standards. And that can only happen if you have this idea that for every fresh use of that data, you need to assess it again, take consent, and so on. So again, in the Aadhaar case, this is a good example. The Aadhaar case judgment, right? You had 4 things for which the Aadhaar data was being put to use: welfare, income tax, phones, and banks. And the court actually found that for welfare and for income tax, for these 2 purposes, the compulsory, use collection of data was justified. And of course, you can argue about, disagree about that, but that's what the court held. But for phones and for banks, it's not justified, right? And you can only examine that if you look at each purpose separately and ask yourself, okay, is the use of data for this purpose constitutionally correct or not? And so for that reason, you have this idea of if I give consent or even if I don't, when you're using data for a specific purpose, you must only use it for that purpose alone and not, just like keep it and then use it anytime you want for anything else. The next use must then separately be analyzed and challenged and discussed and so on.
Thank you so much. So we have a request from Raghu Raj, if you could shed light on different models of personal data protection, like the fragmented and limited ones that exist in US and the GDPR of Europe.
I mean, so yeah, that's like a complex issue, and to be honest, I'm not an expert on data privacy laws, but just like to the extent I'm aware, I can outline some of those issues. So I'm not sure what the context of the fragmented. I mean, I'm guessing it means that in the US you don't have like one specific data protection law, but each domain, say consumer laws and banking laws and all that, have their own norms and standards of what privacy there is. Whereas in the European Union, you have the GDPR, which is a centralized data protection law that governs when the state and when private bodies can use that data and for what purpose. And in India, with the drafting of the personal data protection law, that's where we are going. So in most countries which are not the US, you have this second model, which is that you have one overarching data protection law that is there to govern the use of data. And there are some common features across these laws. One, of course, is to define what personal data is. What kind of data is being protected. Biometrics, personal details, demographics, all of that stuff. So there is that issue of what you're protecting. The second is that under what circumstances can the state collect that data? With consent, that's one thing. If consent is not there, then can the state still do it? Public emergencies, health emergencies, and so on. So what are those contours? This whole sense of purpose limitation I just spoke about, and so on. So what are the principles that limit how the state can collect that data? So, again, proportionality just for that purpose and so on. And lastly, there must be all these laws set up an independent body, something like the CIC or something like the Election Commission. So like a DPA, Data Protection Authority, that will adjudicate disputes over the use and collection of data. And that this body must be independent of the state, because the state will often be a litigant before it, and has to, its task will be to prevent abuses of the law. So these are broadly the characteristics of a comprehensive data protection law and presently the EU GDPR is supposed to be the gold standard across the world. And it's interesting to compare the EU GDPR with the Indian bill and kind of see what the comparisons are, what the differences are.
So since you mentioned the Indian Data Protection Bill, we have a few questions which request you to maybe throw light on how
Yeah.
right to privacy has been addressed in the bill.
Yeah, so again, that is a number of issues, and the data protection bill, there are a few problems with that. The one is that it's exemption clauses, that is that when that what bodies are exempted from data protection obligations, and the exceptions to the principles of consent and proportionality are extremely broad. So if you see the provisions, basically, if there is a public welfare, public benefit, effectively the state can bypass the requirements of proportionality, and effectively the bill uses the word expedient. So if it's expedient, the state can collect all that data. So it really dilutes and weakens the standards that are there across the world. That's one issue. Secondly, if you look at the independence of the authority, the data protection authority, that is compromised by so unlike the election commission, or unlike the pre-amended RTI, which guarantees to these implementing authorities autonomy and independence, the data protection bill does not do that. And thirdly, and I think importantly, there is no mention of surveillance reform, because the government is of the view that surveillance reform is a different thing completely. But if you look at it, actually, there is no legal framework in India that actually regulates surveillance by state agencies, the IB, the RAW, whatever. Now, of course, the argument is not that they can't do that. The argument is that you need to have a legal framework that limits the abuses that they can commit when there is no law at all. But the data protection bill completely omits that altogether. There's no mention of surveillance reform at all. So I think you have these various flaws with the bill, and if you're interested, there was a civil society initiative called Seva Privacy, which drafted the Indian Privacy Code as kind of like a counterpoint to the state data protection bill. And the Indian Privacy Code was meant to bring together best practices from all over the world and inculcate them into Indian conditions. So if you're interested, you can take a look at the Indian Privacy Code that's on the website of the Seva Privacy initiative, and then do a comparison between the Indian Privacy Code and the state's bill, and see what the differences are and what you think about that. Yeah.
So horizontal application of rights has emerged as a claim to the public-private divide, which is maintained by the human rights regime. So in that context, we have a question by Deepak Singh Bish, and what he's asking is that how should we look at the violation of privacy rights by private companies, and can horizontal application of rights serve any purpose?
Yeah, so this is a very controversial issue, and so my view, and this is a view which may not be shared by people. So my view is that there are three things here. One is that privacy has always been a tort in civil law. So breach of privacy for many, many years in the UK, the US, and so on, has been a civil law tort. So if your privacy is breached by a private body, you should be able to go to a court and have a civil suit and get compensation and remedies from that private body. And that was pre-Puttaswamy, and Puttaswamy has no impact on that at all. That's like a civil law remedy. The second thing is what Puttaswamy says, and in my reading, Puttaswamy says that there is a positive obligation upon the state to put in place legislation that will protect individuals from private parties abusing the right to privacy or violating the right to privacy. So the state, under Article 19 and 21, has an affirmative obligation, like in the Vishakha case for sexual harassment, right? There is a gap in the law, and the state must pass a law that will protect individuals from other private parties. And so you can go to the court, and I think this is what's happening in the whole Facebook, WhatsApp cases in Madras High Court and now in the Supreme Court. You can go to the court and you can say to the court, look, the state is failing its obligation to protect me from the abusive practices of private parties. And that in that case, the respondent will be the state. Right? The third option, and I think that this is what's not allowed by the law and Puttaswamy, is that you file a constitutional case, or like a writ under 32 against a private body, say Facebook or Twitter or whatever, saying that Twitter or Facebook has violated my right to privacy, and so I'm going in writ proceedings to the Supreme Court to vindicate my right to privacy. Now, my view is, and people disagree, is that you can't do that because Article 19 and 21, which are the sources of the right to privacy under the Indian Constitution, are both very clearly against the state. They are vertical rights that are applicable between individual and state. Article 15, Clause 2, Article 17, Article 23 and 24. These are the four horizontal rights in the Constitution: untouchability, forced labor, child labor, and so on. If something falls outside these four clauses, in my view, you can't have a horizontal right over there under the Constitution. You have to either go in civil proceedings or go to court and say the state is not discharging its obligations by regulating these private bodies.
So also, because we are talking about horizontal application of right, so do you think that data protection laws should sort of link right to privacy to right to be forgotten, and how far that right to be forgotten has been taken care of in the Indian context?
Yeah, and it's a great question, and I think this is very, very controversial, and actually I still haven't I don't really have a firm view on this, because the right to be forgotten has its plus points and minus points. So if you see how it began, right? It began in this case of Google versus Spain, where this person in Spain basically found that there was some information about him from 19 years ago or something of that kind, that was on the web, and he wanted it to be taken down and not appear in search results. And so the European court said that, look, yeah, there is a right to be forgotten. You can make Google remove those search listings. I think that is a double-edged sword, because in some cases there might be issues of public importance that people need to know about that shouldn't be removed from the internet. This whole idea of like historical memory and so on, right? On the other hand, there might be like purely private issues that you don't want to be there on the net about you. And so I think that any legislative or judicial articulation of that right must proceed with great caution to balance these concerns. In India, you have a couple of judgments in the Madras High Court and Delhi High Court that recognize the right, but don't yet really elaborate upon it. I think there's a pending case involving Indian Qanun, and somebody wanted to remove their case name details from Indian Qanun. I think that's presently being heard, and that might be a good scope to develop the right further. But to answer the question, that I think that presently in India we haven't yet really carefully articulated the right in court cases so far, and without really limiting its scope to ensure that people can't remove issues which are clearly of a public interest from the internet. It makes sense to like take into account when developing the right further.
We have a question from Professor Mahavir. As to how would you comment on the right to privacy in the light of emerging issues of lynching and cow vigilantes? As a few states have provided immunity to the cow vigilantes, and although the Honorable Supreme Court has laid down guidelines, but it has not yet declared unconstitutional the law which does provide immunity to the cow vigilantes.
So I think that, sorry, the immunity in what context? The immunity in not revealing who the identity is, or is that the question? Because I'm not sure I know what the immunity specifically refers to here. Sorry, can you hear me?
We can hear you.
So I think there's something frozen. No, I was asking that I don't think I know what the immunity refers to here. So if you could tell me what the immunity specifically is about, then I can respond. I think Professor Anumeha has just gone offline.
the laws provide for a good faith immunity clause. So, for example, Section 13 of the Maharashtra Animal Preservation Act reads, no suit, prosecution, or other legal proceedings shall be instituted against a person for anything which is done in good faith or intended to be done under this act or rules made thereunder. I think that is what is the kind of immunity we're talking about.
Right. So, I mean, I'm not sure this is a privacy concern as such. I think this is more of a rule of law concern, and whether you can grant immunity in this way to in this context. So I mean, I'm not sure if there's a privacy issue here. I'll need to think a little more about it. But prima facie, I'm maybe I'm misunderstanding, but I can't quite see what the privacy concern is with these clauses. It seems more of a right to life kind of a rule of law concern. But I'll think more about that.
Yeah, thank you. Sorry, my connection got disconnected. Sure. So we have a question from Arushi Yadav. How does one draw a balance between the government selecting the least intrusive measure possible each time, as the least intrusive measure can also change with time? And what must be the least intrusive today might be third led intrusive a little ahead of time. So can a possible critique of the same be that this will lead to judiciary usurping the executive arena of forming policies?
No, so I mean that's a fair concern. But if you look at the way that the principle is articulated, right? It's not that you effectively kind of like take over policy. It is that you question whether the state's framing of policy has complied with the constitutional standard. And so to answer the question about whether things can evolve, so that obviously can happen, right? But what you test is at the time at which you bring the constitutional challenge. At that point of time, was the method picked the least restrictive one? Now, of course, once the method has been picked and it's in progress, something else may arise in the future. But obviously, you can't hold a state to like then change, Suppose, for example, Arogya Setu was working, perfectly well and had taken care of all privacy concerns, and was upheld and all that. So let's imagine that there was a contact tracing app that was decentralized, that took account of privacy concerns and was being used and was in progress. Now, 1 month later or 2 months later, when the app is well, into its like use period, then you find something that is even less restrictive. Now, obviously, given that you already are doing the program and you obviously then can't roll it back, that wouldn't then be a ground to strike down the app. So it's basically least intrusive at the time at which you frame the policy and at the time at which it's being implemented, because nobody can tell what will happen in the future. So I think it's limited to that time period.
Yeah. So we have a question from Vineet, and the question is that the notion of security interest of the state appears to be a limitless justification for the infringement of rights, because complete security agents, terrorist attacks can never be ensured. In order to have a justification for the rights to continue existing in this permanent state of emergency, it needs to be claimed that a degree of risk is acceptable and normal. So on what basis can that judgment be made, since it appears to devalue the potential loss of life, which is a controversial moral judgment?
Yeah, I mean, that's a really difficult question, and ultimately, I think comes down to the extent to which the courts are willing to express certain kind of skepticism about the government's claims. So a somewhat controversial example is this whole issue of the internet shutdown in Kashmir, right? Now, it's not a privacy case, but just it's raises similar concerns. Now, if you look at the research on the point, the existing research on the point and the Stanford University report on this has basically found that an internet shutdown, no matter where you do it, it's not about Kashmir, anywhere in the world. Actually, there is no tangible connection between internet shutdown and increase in security. Any correlation, in fact, goes the other way around, because just as the internet is a medium for spreading rumors and so on, equally well, it's an equally fast medium to quash those rumors and actually put out the state's version, the correct version. If you actually take away the internet, you are ensuring that there is no way to check the spread of these rumors, because then you don't know what the rumors are, because they're all taking place kind of offline. And this is what the report says. There is research that shows that's what the impact actually is. Now, if that's the case, then the internet shutdown, it's not even about being the least restrictive measure. It's basically there's no rational connection between the internet shutting down and preventing violence. So on its own terms, the argument fails. Then the state comes and says that, look, in our judgment, we think this is the only way to prevent violence, despite the fact that there is no evidence showing that it actually has the effect. Now, I think in that situation, it just comes to a question of how much deference a court is willing to accord to the state, and that's, I think, a function of legal culture. In some legal cultures, there is a trend of skepticism towards the government's claims, and in some there's a trend of deference. Our courts have been more deferent over the years. I think there's no one specific answer that you can give to that dilemma, apart from it being a question of how far you're willing to defer to the state's claims. Because if you defer too much, then this whole idea of security, as the questioner rightly said, can ultimately make rights meaningless, because wherever you have a case, you can just say, look, security is an issue, and once I say security, then there's no further discussion to be had. Or you can say, look, I mean, you're saying security, but give us some evidence to show that actually the steps you're taking have a proportionate connection with maintaining security, and then that will require the government to actually demonstrate with evidence that there is a connection here. And sometimes you'll find that when you ask those questions, it becomes hard for the government to demonstrate, because there actually isn't a justification. Whereas in some cases there is a justification, obviously. So I think that this is a kind of a case-to-case issue that depends on what kinds of questions the court is willing to ask and how far it's willing to go in kind of pushing the government to justify what it's doing.
Thank you for that response. Now we have another question, and this is in furtherance of the argument that you made that right to privacy is primarily a vertical right, not a horizontal right. So the question is that how do we take it from there in the context of threat to privacy from private actors, particularly MNC situated elsewhere in the world? So how does...
Yeah, I mean, with MNCs, I think it's really a question of litigation in international fora, because it's very hard to enforce judgment against an MNC in Indian courts, and so you'll end up getting into questions about private international law and things like that. But I think that, so my own view is that if you actually look deeply into the civil, into privacy as a tort, civil right to privacy against other private parties, you'll find that the existing level of protection of the tort has been developed over the years is quite good. So in my view, you actually don't need a fundamental right to privacy against a private party, because the existing tort covers the same ground mostly. And so what you need is a functioning civil law system where a civil suit can actually be decided like in a short time, and you can have an efficacious remedy. You need that kind of infrastructure and the procedures to be put into place that will let you enforce these rights against parties like Google, Facebook, and so on with heavy damages. A writ is not going to really help. And of course, you need the state to take into account its obligations under the Constitution and frame that privacy law as quickly as possible. That will then give people a specific remedy against violations by private parties. I think ultimately it's a combination of the of privacy as a tortious remedy and the privacy statute the government needs to pass that can then deal with specific breaches. Because ultimately a constitutional right is limited in what it can give you, and also it's kind of at an abstract level. Specific breaches have to be dealt with by tailored legislation. It's much more effective that way.
Thank you. So I think in the same context, there is another question that what should be the approach toward invasion of privacy and individual profiling, which is done by such social media platforms? And do you think there is a model or a legislation which any country has drafted, which may serve as an ideal model to control such artificial influencing of political process by private?
Yeah, entities? I mean, not yet, because I mean, you can see after Cambridge Analytica and you know, the use of Facebook ads and things like that, it's a big issue right now. And in fact, for Facebook, you actually have, Facebook has just said it's not going to look into accuracy of political statements. It specifically said we will not, consider if this is fake news or not. And so I think you have a big issue with big private intermediaries or platforms being used to profile and to I think politically influence events. I don't yet think there is a model in place that deals with it. We have good writing on it by people like Zeynep Tufkil, and I probably got her name all wrong. But you have scholars who have written about how we can regulate this. And the consensus seems to be that these internet giants have grown so big that you can't at this stage regulate them. The only way is to break them up into like smaller entities so that they lose the monopoly influence that they've effectively got. In the long run, and certain American politicians are now proposing this, the only way forward is like you break up big banks, like you break up monopolies in other domains, you break up tech monopolies, and that's the only long-term sustainable way of ensuring that the power they've accumulated is kind of like dispersed and cannot be used to influence political, choices and even beyond that, specific profiling and things like that.
Thank you so much, Mr. Bhatia. I think this was an extremely informative session, and we got an opportunity to explore different contours of privacy and what are the different possibilities and expectations that we have from the manner Puutaswamy has unfolded right to privacy. Now I would.
The questions were great, and I really enjoyed them.
Thank you so much. Now I would request Harshita Singhal, final year student at the Campus Law Center, to give concluding remarks.
On behalf of Campus Law Center, Faculty of Law, University of Delhi, I take this opportunity to thank Mr. Gautam Bhatia, our speaker for the day, who's a practicing advocate and a constitutional law scholar at Oxford University. Mr. Bhatia has been generous enough to spare his time for students despite his busy schedule. This talk was yet another example of how he puts every issue related to constitutional law in simple words for everyone to understand, just like his blog on it, Indian Constitutional Law Philosophy, and his books on the subject. I express my gratitude to our professor in charge, Professor Dr. Raman Mittal, our faculty members, Mr. Prakash, Meena, and Ms. Anumeha Mishra, for their efforts and guidance in conducting this webinar. I would also like to thank Mr. Abhinav Garg, President of All India Law Students Federation, who's been working tirelessly on the background to ensure that this webinar has no technical glitches. This webinar would not have been possible without the support of our student volunteers at Campus Law Center, and I extend my heartfelt gratitude to them. Thank you.
Thank you, and I hope to be with you in